Okay. Once the arraignment takes place, once a person makes a plea, let's go over the three pleas. You can plead not guilty. You can plead guilty. You can plead something called nolo contendere, which is a Latin term. You have Latin all over my class. Nolo contendere means no contest. Okay? Nolo contendere usually is a plea that is done in cases that are not felony related. And the reason that they're done in cases that are not felony related is because oftentimes if you plead guilty in a case, let's say that you had a traffic accident and you said to the court, okay, I did it. You're going to be sued civilly, and your I did it is going to be used in the civil case to get money out of you. So rather than saying I did it, what you are in essence saying in nolo contendere, which means no contest, is judge, I'm not going to tell you whether I'm guilty or not. You make the decision. So the judge makes the decision. The judge's decision cannot be used in a civil case. So that's what nolo contendere means. And from our purposes, it doesn't mean much. Guilty or innocent. In 90% of all cases, a person pleads not guilty. Why? Because if you plead guilty, they can sentence you right away. And you have nothing to bargain for. So oftentimes people say, yeah, I may have done it, but as long as the government has to prove it, there's that little chance that they may fail. And rather than take that chance, they may give me a better deal, better sentence. In the case of this girl, one of the things that the government did is that they dropped the 27 charges of drug possession. She had 27 separate charges of drug possession. And they dropped it to 1. And she pled to going to rehabilitation. So by her pleading not guilty, the government had an incentive to cooperate and drop the charges. Okay? That's what happened in that particular case. Now, after the arraignment, what takes place? Well, what takes place is what is the art of the law. After the arraignment and up to the trial, the art of the law takes place. By the way, in the arraignment, they tell you, your trial date is on this day. Okay? And the date is generally within the speedy trial rights, which I believe is 180 days, but I'll tell you exactly how long it is. I'll check and let you know exactly the number of days. But between the date of your arraignment and the day of the trial is really the investigation. Both sides try to learn as much about the case as possible. I'll give you an example, which is a really good example. This morning in the news, apparently some lady decided to drive on the highway the wrong way. And even though that might seem laughable, in this case it wasn't laughable because she drove head-on into a car that had 2 people in it, and they died.
All 3 of them?
No, the lady actually survived. She survived it, but she killed 2 people. It turns out that the reason she was driving, or one of the reasons she was driving backwards or the wrong way on the highway, is because she was drunk.
How do you even get on the road?
Now, her attorney said to the court, I think that there's a defense because I think that we can say that she was involuntarily drunk. In other words, somebody may have forced her to drink, or somebody may have put some additional drinks or narcotics in her stuff, and she was not something that she did on purpose. Not something that she did on purpose. The period between the arraignment and the trial is the period where both sides begin to investigate claims like that. Now, one of the things that the judge said, what the government is going to look at, is they begin to investigate. Could she have been drugged? Could she have been forced to drink? Well, it seems that the government said, you know, Judge, they're saying that, but in our investigation, we found out that she tweeted. And she put something on her tweet like, drunk and dangerous and don't care.
How old is she?
I think she was probably about 18 or 19.
Wait, I think I've heard of this.
Oh, yes.
Drunk, dangerous, and don't care. So the judge said to them, you know, if you're saying that she was forced, you're going to have to explain why on her Twitter it said drunk and dangerous and not care. Because it sounds like she knew it, she did it, she didn't care, and the consequences are the two people are dead. The period between the arraignment and the trial is the period of time in which both sides investigate. Finding things on Twitter is one process of investigating, because what they're trying to find is evidence. And evidence, like the Twitter information, is something that goes to the heart of the issue of guilt or innocence. Now, if you said, look, I'm drunk, I'm dangerous, and I don't care, and you went driving, that statement goes to the heart of whether you intended to do it or not. Peter, could you please stop it for a second?